Judiciary hearing. We are going to start by opening with a word of prayer. I'm going to ask our Majority Caucus Chair, Senator Kennedy, if you'll please open us up. You are mic 9.
Don't have a number. No, that's not. I think I'm 10. Yeah, there we go. Okay, thank you. Thank you, Mr. Chairman. Good afternoon. Y'all, please join me. Heavenly Father, thank you for the day that you've given us. Thank you for the opportunity to come serve the people of Georgia. Please bless us and bless the process that we will go through. Make sure that we ensure that everyone is treated with kindness and respect. Thank you for all the blessings that you've given to our state, and please keep them coming in Christ's name. Amen.
Thank you for that. Before we get started, a former colleague, Senator Heath, always accused Chairman Stone of sucking up to judges, but I'm going to keep that tradition alive. And we have a judge visiting us with us today is also a former colleague of mine in the House. We used to serve on the House Judiciary Committee together. Judge Dusty Hightower from the Coweta Circuit. You want to come say a few words? All right. Good to have you, Judge. All right. Thank you for anybody else that I've missed. He always did that too. Judge Whitaker. See, that's why I shouldn't do this, because I didn't know Judge Whitaker was with us as well. Good to have you too. All right. We have 2 bills on the agenda. We're going to start with Senate Bill 197. And if you want to come on up, Senator Jackson, we had a sign-up sheet out to speak on these bills. Anybody else need to sign up to speak for or against Senate Bill 197? All right. Also in your packet, there are letters that were given to the committee in advance for and against the 2 bills that are on the committee calendar for today. If anybody else has anything else they want to distribute, please let us know that as well. And with that, I will give you the floor, Senator Jackson. I will also state we heard this bill last year in committee, those of y'all that were here, and passed it out last year. If you will please let us know if this is the exact same bill, any changes that you made, and also to refresh our memory, still walk through the issue for us, please.
Thank you, Mr. Chairman. So I am reading from, this is the exact same bill that you all passed out of committee very favorably in the past. So let's keep that in mind. But I'm reading from LC 280189. You'll note that this is there are very few changes that are being made here. We talked about this last year. So this is pertains to the issue of stalking and how we define what stalking is. Currently, the code allows for a person, if you are inside of the defendant's home, then they are excluded from any accountability when it comes to stalking. So the way that we've read so far is that, if you're stalking somebody other places, we can charge you, but if it's inside the defendant's home, i.e. if you share a home with the defendant, then they cannot be prosecuted for stalking. So this seeks to change that by striking other than from the language to include that this is for the residents of the defense as well. And so let me just tell you a story. Let me tell you, there's a reason behind this, why we want to make this change, and they're real live reasons and real lives that are at stake. So we've changed the names of the people in order to protect their innocence. But there's a woman named Allison who she was living with her partner still. They were separated, but they were sharing the same home. And so she was doing her best to kind of make that situation work as she had to, and to try to ignore him and just try to make that separation while they shared the same home happen. But the longer they lived there, the more it became clear to her that Andre was unwilling to cooperate. One day, Allison was in the bathroom and she recalls locking the bathroom door when she's startled to discover that Andre is staring at her in the shower with his face pressed up against the door. She screamed about it and Andre was just like, oh, and he laughed at her. There were 2 other occasions, at least, where she was also in her bedroom and she looked outside her window and there she saw Andre staring at her while she was dressing. Andre said he was just hoping to catch her involved in some self-pleasure. But for Allison, she was clear that he was, in fact, stalking her. but there was no opportunity for protections for her. Now, there are a couple of things that I want to go ahead and address up front. First of all, stalking is a real issue in our state. And it's often referred to as kind of a gateway crime, if you will. What we know is that 58% of Georgians who die through a domestic violence act, that 58% of those reported having been stalked before that happened, stalked in their own home. And so if we want to save lives, if we want to protect people, then this is one of the ways that we do this, is we provide this access to being able to get stalking, a stalking TPO ultimately, so that people can get to safety. I think I'll stop there and entertain any questions.
Have any questions for the author of the bill? Senator Coweta.
Thank you, Mr. Chairman. Senator, we appreciate what you're trying to do here. I had a question I really thought about over the off season. I was thinking your bill had passed last year. I guess it's just it had come out of this committee. Mm-hmm. Have you given any thought to treating the aggravated stalking different than just the misdemeanor stalking? You know, to be aggravated stalking, it's where you're in violation of a temporary restraining order, the terms and condition of a bond or whatever. And to me, that makes a little bit more sense. If you know this person has exhibited some type of inappropriate, intimidating or threatening behavior, to extend the protections to the household after such an order has been put in place. But otherwise, it just seems so hard to determine, if we're talking about roommates or spouses, whether there's some purpose of harassing or intimidating. I mean, it's so nebulous to define that.
Sure. So the problem with waiting until there's aggravated stalking is that, first of all, you had to have gotten a stalking order in the first place for there to be aggravated. And right now they can't get that because the stuff is happening inside of the home. But additionally, it just opens up a victim to being terrorized more greatly if we wait until there's an aggravated stalking felony offense that's happening. So this allows, if we do it now, we can catch it early on the misdemeanor, and people have the opportunity to go before a judge and to make their case as to whether or not they actually qualify for a TPO for stalking or not. I mean, that's the good thing about how this works, is that, you can't just say, hey, he's stalking me or she's stalking me, and that person gets prosecuted, right? Like, we have a judicial system that would have to weigh that out. And if they apply for a TPO, there's a judge that will have to weigh that out as well in order to make sure that those allegations, that there's something supporting them.
Well, I'm not seeing the judicial system hesitate in any way. I mean, I think if anything, there's more encouragement to prosecute these type of sexual harassment crimes. And if somebody comes and makes a complaint to law enforcement, there's nothing that stops them then from essentially ejecting you from your own home where you're paying your rent based solely on an accusation. Well, let's say the shower girl made that up. Mm-hmm. Then her roommate just lost his place to live. Based solely on her accusation, there has not been a previous good behavior bond, no terms or conditions of a bond, or no prior convictions. I mean, I just worry about the old, innocent till proven guilty end of things.
Right, certainly. And so, but this is how our TPO process works. This is not anything different than a domestic violence TPO. It's based on evidence that a person is able to bring to a judge to get a TPO ex parte and then a longer term. So they can't just sit before a judge and say, hey, he was looking at me in the shower, and Judge Whitaker can speak to this. She can't just say, okay, you said that, therefore I grant you a TPO. Right? Well,
you can under 16590, though. You can prosecute them and put them in jail for the offense for looking in that shower now, because that is no longer a protected place. That's the aggravated stalking where you had to have a TPO first.
Right. I think for me, I just want to be clear that our goal here is to protect people. And we have known stories of people who have had spouses, partners, people with whom they share a home. They have been stalked in their own home. And what we know is that 58% of the people who have died by the hand of their former spouse, partner, whatever, 58% of those were stalked beforehand. So that's what we're trying to disrupt is that incident. And is it possible that somebody might lie about it? It's very unlikely. It's extraordinarily unlikely that somebody would lie about it. But I'm much, much more concerned about the 58% of those people who die.
Yeah, but those 58% would fall under my definition of aggravated stalking, because they would have already gotten the temporary restraining order. So there would have been a screen. Some judge would have said, yeah, this is a credible claim.
So help me understand how they would have gotten the TPO.
Because that's a definition of aggravated stalking. They would have first had a temporary restraining order, a temporary protective order, a permanent restraining order, permanent protective order, preliminary injunction, or good behavior bond. You would have had to violate one of those to be aggravated stalking. So to have one of those, the victim would have had to go to a tribunal and persuade them that there were reasonable grounds to pursue their charge. On the misdemeanor stalking, there is no such prerequisite. So then it truly is, instead of going to court first and proving your probable cause, a police officer can simply arrest the roommate because their roommate alleged that they did something that had the purpose of harassing or intimidating them, even though they had the legal right to be present at that location. That's where I'm having a little bit of consternation.
Right. And I'm following you. And I think my piece is a person can't get a TPO right now for the behavior that's happening, for the harassing and intimidating behavior that's happening inside the shared home. That's not available to them. So therefore, there can't be a violation of a TPO. So you can't get aggravated stalking in the first place because they don't have access to a TPO. If all of the stalking behavior is happening and it's contained inside the shared home, there is no pathway for a victim to get a TPO or even get a stalking charge on a criminal side either. There's just simply right now, as the law states, there's no pathway for that person to receive protection.
Okay, thank you, Senator.
Senator Tillery.
Thank you, Mr. Chairman. Senator, did we not pass a bill last year, maybe it was 2 years ago, that would allow in situations such as this, if someone, and even if they're not in the same home, where rent would be essentially voided?
It's not voided. That was my bill. Yes, you all passed that. Thank you.
And I think I helped supported you on that bill.
You did. You all voted unanimously,
So
both here and on the floor.
So that's why, the butter before the rest of it. So I have a problem with us when we begin to invade somewhat into the castle doctrine of homes. And I understand what you're trying to do on the bill. I appreciate that, but I wanted you to hear it from me. Of my issue on the bill is not to hurt any more folks who are experiencing domestic violence of any kind. My way to fix that was the bill that you first proposed. And I understand you're coming back now to get another bite at the apple. And I appreciate your zealous advocacy of those individuals and victims. But the reason that I just won't be able to support this bill in committee will be because of what it does to homes. And I'm afraid that if we move to where the home place is not right now, it's a safe harbor of ways from the defendant, it worries me for where we go forward. And I just wanted you to hear that from me.
Well, I appreciate that, Senator Tillery. The reality is that a person cannot access that great bill that you all helped us pass and make law if they can't get the TPO in the first place. So our tenant relief does no good for the person who's in a shared home and being stalked. It makes that bill null and void. And the last thing I will say is that certainly I respect the importance of our castles. I want my home protected as well. But the reality is that if you commit a crime inside of your home, it's a crime and it's illegal and we need to prosecute it. I can't kill somebody in my home and go scot-free from that, right? And therefore, you should not be able to abuse or stalk somebody in your home and go scot-free with it simply because it's your home. And that's what I'm saying. This is criminal behavior, and it needs to be treated as such and prosecuted as such, even though it's happening inside of your house.
And Senator, thank you for that. The concern I have is because of the other laws that we've created around aggravated stalking, domestic violence, TPOs, et cetera, for the other effects that it may have before you could get to, as you said, a process that right now might be slightly delayed with courts. And I appreciate that. Thank you.
Thank you.
And Senator Jackson, it was pointed out, line 29 of your bill, we have the effective date still July 1st, 2021. I don't know what that would do legally if it passes and it becomes effective a year ago, but obviously we'll need an amendment if the bill is going to move to make that 22 for your bill. We have a question, Senator Hatchett.
Thank you, Mr. Chairman. I just wanted to clarify something. When you were testifying earlier about TPOs, right now someone can get a TPO against someone who lives with them for domestic violence or other issues, but you're saying they just can't get a TPO for stalking.
That's correct. They can get a TPO for violence. So if someone lays their hand on someone, then they have access to a TPO. But we're trying to avoid them getting all the way to the point of having their face bashed in, because oftentimes we see stalking behavior is a predicate of before we get violence.
Okay.
Does that make sense to you?
Yeah. No, yeah. I was just clarifying. Thank you.
Any other questions for the author of the bill? All right, we have one, Senator Kennedy.
Thank you, Mr. Chairman. Senator, thank you for bringing this. And sort of bootstrapping off of some of the questions that we've heard already. Did you look at the various laws that are available in the criminal code for someone to seek help, like what you've described, but outside the stalking statute? Part of what I'm struggling with is stalking to me necessarily connotes a certain distance. And that's probably why it was initially excluded, that the residence of the defendant was excluded initially. And part of some of the last questions and what Senator Tillery said is concerning to me too. It changes the dynamic of that home in a way, in some respects, as you described, may be needed, but I'm trying to think of all the other permutations and how this might unfold in ways that might be unintended consequences. So I guess that's a long question, but did you look at, are there other statutes on the book that could afford someone that would be defined as a victim in the example you gave, but not necessarily travel under the stalking statute or that line of thought?
Certainly. So it depends on the type of stalking behavior that's happening. If a person was wiretapping their spouse's phone, then certainly they could possibly be prosecuted under wiretapping. However, that doesn't give them access to the very special protections that you would receive through a TPO for stalking. This is a large part of this is about giving people access to a temporary protective order so that they can receive the protections that they need. So, we can kind of do a whole list of what are other crimes that are happening in the process of stalking, and couldn't we prosecute those? Yes, but you can't go and get a TPO for that, and that's what we're trying to access. Does that make sense to you? And I think the last thing I want to say about that is that it's still prosecuting somebody for behavior in their own home, which is something that you all are kind of pushing back against. So I don't know where else I'm supposed to go. If I go to a different section and it's not stalking, I'm still looking in the criminal code for a criminal act that we're going to prosecute that's being done by somebody inside of their own home.
One follow-up, Mr. Chairman, if I may. And obviously you've spent some time looking at this, and I appreciate your expertise on it and the experience. In your experience, has the remedy that's been fashioned by the court under this statute typically included some sort of distance minimum, and that is that the parties now have to maintain a certain distance from each other?
That's right. There would be a stay away order of some type so that people wouldn't, you are correct that somebody would not be able to stay inside of that home. However, who the person is who would have to leave that home, that is not predetermined by our current law. That would be determined by a judge after hearing the circumstances that are at play. I would argue that if the defendant is the one who legally owns the home, there's a high likelihood they're going to be the one who stays, and then the person who is the victim is the one who's going to be put out, because that will be the judge's call, right? So I think it's just really important to note that there is, there's an arbitrator here. This will have to be heard before somebody, and there has to be evidence that's being offered up before somebody could be separated from their home.
Any other questions for the author of the bill? All right, thank you. If you'll sit tight, we have a couple folks that have signed up to speak on the bill. We'll start with Maisie Lynn Guertin with Georgia Association of Criminal Defense Lawyers. Good afternoon.
Hi there.
How are you?
Well, thanks.
Good.
When we were here, hello, good to see you all. Happy New Year. This is the first I've been before you this session and this year, and glad to see you all are here and healthy and well. Our concerns about this bill remain the same as they were last year, and several of you have articulated many of them today. We have been in conversations with Senator Jackson for some time now, and I just am really grateful to her for being open to considering our position. She has really worked hard to try to find some ways to thread the needle of concern that we have, but so far we've just not been able to come up with language that quite does that. And frankly, even if we could find this narrow path that I'll tell you a little more about, I'm still not sure our organization could ever really support the bill on the whole because of the concerns we have around someone's right to remain in their home free of this sort of criminal encumbrance. As the conversation has unfolded today, it's caused me to realize that I think one of the gaps that maybe, and we haven't specifically talked about, is the line between what a simple assault is and stalking. Because under our stalking code section, it is true that someone cannot be criminally accused of stalking in their own home. However, they can be accused, as you all have mentioned, of family violence predicated on simple assault. Simple assault requires that the language being used against someone, it does not require any touching, does not require any actual violence, but it does require an immediate fear of violent contact. So I do think that there probably is some space, and I would expect a judge would find there could be a space between what stalking is and what simple assault is. It's probably pretty narrow, but it probably does exist, and I will at least come to admit that. The other part of this that's been a puzzle for us is the situation where if both the accused and the alleged victim have a legal ownership, whether it's the lease, the mortgage, the title, whatever sort of legal right to be in the residence, that becomes more difficult for us to kind of stand against. We do feel like, though, when it is one person's home, it is that person's home. And if the alleged victim is not on the lease, is not on the mortgage, does not legally reside there, that person is in the best position to not be there. They have no reason to have to be there. And we believe that therefore the person who does live in legally own, rent, however, the home should be able to be there without this crime being attributed to them in their own home. But as I said, we have worked diligently with Senator Jackson to try to find a way specifically to address the second point that I mentioned. But like I said, now today we've talked more and heard more from some of you that I do think there's also this other narrow space between simple assaults and stalking. Unless there were some modifications to this bill, our organization certainly can't support it. And we would ask you to fail to send this out of committee today, if nothing else, just so that we could work more diligently with Senator Jackson about these two issues that we have.
I have a couple questions. As far as dealing with the situation where the defendant owns, sorry, turn the volume up, now I'm really loud, where the defendant owns the residence, but the victim has no legal right to the residence, couldn't you have some language in the law that has it where the judge will consider that, or at least give some weight to a sole owner in that situation where it's the defendant that actually owns the property as far as who gets the house? I mean, couldn't that be resolved with some language?
Well, that could be resolved within the sort of protection order context, but this is, we're talking just in this legislation about the actual crime. And so if you've already been accused of the crime, certainly I do, and as Senator Jackson said, I believe judges do make that determination every day about who stays in and who doesn't get to stay in with respect to bond orders, for instance. Right. But when you're talking about whether or not you can actually be accused or the crime can be formed based on the fact that it's your home, I do see that as a distinction.
But what is someone to do that's a victim and they're legally, let's just use a situation where they're both on the lease and you're living in a place and you're being stalked by the person you're living with. The only remedy that I'm aware of under the law now is to move out. And then if the stalking continues, then the person could be found liable for stalking. You could go get a TPO. Is there some other option for the victim in those situations?
I don't think under our law we do until it rises to, like I said, the level of a simple assault, or if, for instance, a battery were to happen. I would agree that we do not have a good remedy for that narrow class of people, which is exactly what we tried to work with the senator on, trying to circumscribe. But I will say, just in full transparency, one of the problems with trying to find a middle ground on that issue is the ability for the leaseholder, whoever that person is, to have a certain amount of control and power. And what we hear about in these types of cases in the courtroom all the time at these hearings that we've talked about is that is one way that people who are accused of abuse seek to control their alleged victims. So it just gets very complicated and how to sort that out, because I realize how black-hearted it sounds for me to sit here and say that person ought to leave and go find somewhere to be, when I know that that can be a very difficult situation for them.
Right.
And I truly don't mean to sound so heartless, but I also do want to protect the people who could be, as Senator Calzert mentioned, falsely accused. And this type of false accusation doesn't stop at this criminal charge. If you move into a TPO for stalking, you can lose your school scholarship if this happens on a college campus. You could lose your enrollment in that college. You could lose your job if you happen to be in a place where you need to be near that person for some reason. I mean, you could lose your housing depending on how the situation's worked out. The impact of this crime and where it goes is pretty broad. But I also realize that the impact on the people who are alleging this type of abuse is also hard. So I don't envy your position, but I still would ask you to not support this bill as drafted.
And to make sure everybody's clear, as far as TPOs, you're referencing, it was referenced earlier, the family violence TPO, where if there is a battery or an assault that occurs within a home, someone could get a TPO under that law. But then there's a stalking TPO that is before there's any violence, if there's going to be violence. And that's the situation we're dealing with here. Any other questions for Ms. Guertin? Okay, thank you.
Appreciate you hearing from us.
Thank you as always. Next, we have Judge Whitaker from Fulton County Superior Court. Good afternoon.
Good afternoon, Mr. Chairman and committee members. Thank y'all for this opportunity to appear before you, and I am here to hopefully answer any questions that you might have about legal ramifications. I know there have already been a lot asked. I'm here both in my position as a Fulton Superior Court judge and as vice chair of the Georgia Commission on Family Violence. I think that what we don't want to lose sight of is that you as a legislative body have already recognized that stalking is a crime. And in order to establish stalking behavior, even to get a TPO, a stalking TPO, it's not just a one-time incident. It is a pattern, a course of conduct that is knowing and willful, that is directed at a specific person, and that is for the purpose of harassing and intimidating that person, and that puts that person in reasonable fear of danger to themselves or a family member. There is a difference between that and assault, because to be found guilty of assault or to secure a stalking TPO or a family violence TPO based on assault, it has to be immediate fear of immediate bodily injury. If you are a stalker and you know that you can get away with stalking in your home, you can say to your victim, your intended victim, I'm not going to kill you today. I'm not going to kill you next week, but by God, one day I'm going to kill you. That's not assault. Is it, if you say that every morning when the person gets up, intentional, willful conduct that is designed to terrorize, harass, and intimidate that person? Yes, it is. And so that is something that you all have recognized anywhere else, it's criminal, but because it's occurring in the home, you're simply saying, we're giving you a pass. You can get away with this as much as you want to. And 47 other states already recognize that that is not a good exemption to provide. And we think that Georgia should join the rest of her sister states and not be the last one on this, and go ahead and recognize that simply because it occurs inside a home, if it is in every other way meeting the definition of criminal behavior, it needs to be treated as criminal behavior. But I'm happy to answer any questions. And I do, with regard to the TPO issue, TPOs come before Superior Court judges all the time. And yes, we do take into consideration all sorts of nuanced factors, including who actually owns the home, who might have a relative they can live with. It's not automatically the person who is the alleged harasser. And we realize that at that point, it's not a beyond a reasonable doubt standard yet for the TPO itself. What we're talking about here is the stalking statute, the stalking crime. So I think we do have to keep that in mind. But yeah, we do look at all of those nuanced issues when we are deciding whether to issue a TPO. I think Senator Jackson's point was you can't secure a TPO under the stalking statute as this stalking statute currently exists, because we're simply saying it's otherwise criminal, but it's not going to be criminal if you do it in your home.
And Judge, to be clear, the stalking TPO uses this definition from this section though, correct?
That's correct. Yes.
And are you familiar with Georgia law when it comes to surveillance and eavesdropping within a residence? And basically the right that someone has to place somebody under surveillance in their own home. Are you familiar with that law?
am.
Is there any concern that that law contradicts what we're doing here if we were to pass this bill?
So, I think that is going to come down a lot more to the specific situation. So it has to be a private place where there's an expectation of privacy. And, if the two people are still sharing a bedroom together, there's probably not an expectation of privacy there. So it's going to be very dependent upon what the circumstances are. And again, and that wouldn't require a course of conduct, but that might not be able to be reached because of that part of that statute.
But if someone, for example, is in a divorce and they have surveillance on their home to catch their spouse having an affair, wouldn't that be a legitimate purpose for having surveillance? That line 26 of the bill of the current law talks about one of the requirements is that the act has a legitimate purpose. When I looked at that issue, that was one of the things I thought if adultery is still a crime in Georgia, if you can use surveillance to detect crimes within a home, that would be a legitimate purpose. That person should not be guilty of stalking. And I don't think this would contradict the current surveillance laws, but if you had any thoughts on that.
So I'm not going to opine on that, but I certainly think that would be a legitimate argument to be made by a defense attorney.
Right.
So I don't think
It's
that
a
would.
very good answer, right? It's a judicial answer. All right, I'll stop asking questions. Mike 11, Senator Cowser.
Thank you, Mr. Chairman. Judge, thank you for being with us today. I'm struggling just a little bit. I mean, I think everybody up here wants to protect any victims of domestic violence or stalking or harassment or intimidation, whether sexual or otherwise. But there was a reason I wasn't here when this original statute was passed and hadn't looked up its legislative history, but it specifically excluded the residence. It said other than, and that's what we're changing. I keep assuming that the reason for that is because there's almost some element of consent when you voluntarily live with somebody else. They can't be barred from following you or looking at you, surveillance or contacting you. Those things are built into being roommates or spouses or boyfriends and girlfriends or whatever, where you live together. It's almost as if there's some consent to some amount of contact. And then we get back into the intent behind the behavior, whether it's to intimidate and harass or not. And it's just so subjective. I feel for you and your job having to decide whether or not to grant those protective orders when you're going to err on the side of protecting a victim at the expense of somebody's right to live in their own home, possibly, you
So I'm
know?
not going to say that I'm going to do that. What I'm going to do is
I would
follow the
hope you
law.
would. I mean,
And if the law requires that before I grant a TPO, I find a pattern of conduct, a course of conduct, and that it is specifically, I mean, it says in here, a knowing and willful course of conduct. And those are very high sort of standards when it comes to the law. So I'm going to have to find that, and I'm going to have to find that the purpose is to harass and intimidate. It can't just be the impact. It has to literally be that person's purpose. So there's a lot in this stalking statute that has to be proven, that are meaningful words to a judge, that are things that are going to have to be shown with evidence. So I don't. And the fact that, yes, it's true that, that's always going to be subject to what I think's been proven and subject to some amount of interpretation. But that's true for stalking conduct that occurs outside of the home as well. It's just as tough or not tough, no matter where it happens. And it is not, I think the research shows that with a lot of these situations, it's not as easy to say, you know what, I need to get out of this situation, as one would assume if you haven't been in that situation before. There are a lot of other impacts that go into people staying in a home with somebody despite that behavior.
one follow-up. All right, so back to this having to be a willful pattern.
Sure.
Senator Jackson's example where the roommate stares at her in the shower one time. That's not a pattern.
It's not
So this wouldn't even help her own thing she's trying to address.
So, I mean, that would be up to a judge to decide. And in addition to that, maybe 3 instances, maybe the judge decides, yeah, I think that was for harassing, intimidating. Maybe the judge believes the other person and says, I think this person's making this up. We have to make those kind of calls every day, that kind of credibility determination. But to get a stalking TPO, not only would we have to find all of the things that I have already stated, but there also has to be a finding that not only has it occurred in the past, but we believe it is going to occur in the future as well.
Thank you, Judge.
Does the stalking TPO language allow the judge to award a residence to someone, or is that just under the family violence TPO statute?
So it could potentially permit somebody to be evicted from a shared residence. Now, it is temporary.
Oh, I know, but I
So-
wondered, I know that in family violence TPOs, on the forms even that are used by the court, there's a place for residence being awarded, isn't there? I believe.
There is.
Is that the same for stalking TPOs as well, where that's something that's
No, I
automatically?
believe so. I mean, I think that
Okay.
that's one of the things that a judge could do. But again, I think that judges look at all sorts of
Sure.
situations in terms of who does it make more sense temporarily to displace to somewhere else.
Senator Kirkpatrick.
You're going to have to pardon my non-lawyer questions. First of all, I serve on the Commission on Family Violence,
know
so
you
thank
do.
you for your service. I don't remember that we went into this much detail when we discussed that bill. And so I have some concerns about private property rights. I have some concerns about surveillance and what that really means in this decade that we're in right now, where everybody's got a Ring doorbell or a nanny cam or a webcam on your computer or whatever. So I'm a little concerned about people being roped in inadvertently to this. But I guess my real question is, you gave the example of a threat that to me sounded like, as a non-lawyer, a terroristic threat. Is that not covered in another part of the law?
So there is a crime of terroristic threats. The catch with terroristic threats is that nobody can be convicted of terroristic threats on the uncorroborated testimony of the alleged victim. And if you're talking about a situation where 2 people are living in the same residence, that may be that all that there is. So that's why terroristic threats a lot of times is not going to be able to be a sufficient safeguard to protect the alleged victim. And also terroristic threats would not permit any kind of a TPO.
Senator Rhett.
Thank you, Mr. Chairman. I'm just trying to understand how this TPO is issued. I'm pretty sure it's not on a one-time occurrence.
It can't be.
And so it has to be based on past actions, because, you know, I was watching a marathon of the honeymooners, and I can count how many times Ralph said to the moon. Well, that's a pattern, you know. So I'm just trying to see how that discernment is made.
So I can't remember what Ralph's wife's name is, because that is slightly before my time, although I do know the reference that you're talking about. But what was her name?
Alice.
Alice. You know, Alice was not, I suspect, placed in reasonable fear that he was ever actually going to do that. That was a shtick they had, you know, it was a way they communicated, but that was not harassing and intimidating behavior. It was a pattern, but it was a pattern of, oh, Alice, you're driving me crazy. Alice didn't think that he was actually going to do that. So that would not count.
Senator Kennedy.
Thank you, Mr. Chairman. Judge, thank you for being with us. In your experience in dealing with stalking cases and issuing orders, maybe on a temporary basis, maybe interlocutory, maybe permanent, is it fairly common that an aspect of that order and the protection and remedy you're trying to fashion for the victim is a restraining order providing some distance between the victim and the stalker?
Yes, it's typically, 100 yards away. Yeah.
Would you, as not asking you to opine about a case is not before you, but given your understanding of this and how you think it would unfold and how it would be implemented, would that aspect most likely be a part of a remedy you as a judge and other judges would fashion for stalking violation here? And that is, you would have the restraining order with a distance of separation aspect?
Are we saying if we make this change that is now being proposed, or even regardless, like as things stand right now?
No, that question was, I thought my first question was as things stand now.
Okay,
Yes.
sorry.
And so this question is, and you can answer both if I probably didn't ask it well, but as you would anticipate this law being implemented and cases being brought before you, would you expect that restraining order aspect to be part of a remedy you would fashion for a victim alleging stalking in the home, if you will, per this statute, if it were changed?
Yes. And the answer is yes, with regard to whether it's changed or not. If the person only harasses at the workplace, then I would include in the stay 100 yards away from the workplace and 100 yards away. I would typically say from the victim, no matter where that victim is.
Okay, thank you.
Senator Jones.
Thank you, Mr. Chair. One quick. So one of the issues here, of course, is about the issue of wrongful accusation, because we're kind of hearing that. But what it sounds like is that with this particular statute, the stalking statute, that the bar is high for the victim. And there's so many steps that you have to take that the statute itself kind of creates guardrails or protections that, of course, anybody can make a wrongful. We get that. But the statute itself probably gives these kind of guardrails that actually may prevent that better than even like a simple battery or something, because you guys really have to go through things.
Yeah, I think that is an absolutely correct summary of the way this law is already written. Yes.
Senator Hatchett.
Thank you, Mr. Chairman. I just have a drafting question about this bill. As the bill is written right now, it looks like it relates to 16.590 paragraph A1. But and I may have to speak to Senator Jackson on this, it doesn't look like the bill as written addresses 16.591, which is aggravated stalking. And my question, if I heard your testimony right, you wanted it to apply to both, but I think as it's written right now, it only applies to one.
So I don't know, Senator, if you want to field it or. Yeah, I don't know the answer.
Okay.
So the aggravated stalking bill typically there already has been some kind of a protective order in place and the person is violating that. They've ignored a court order. The issue with this is that you can't get that stalking order for behavior that occurs within the home. If you could, then you could get, if this change gets adopted, then you could get a stalking TPO. And then if you violated that stalking TPO, you would be potentially guilty of aggravated stalking, but I don't know if that's what you're asking or not.
No, I understand
Okay.
your explanation completely. My question is just when we're trying to amend the definition place or places, it looks like based on the testimony, we're trying to do it in two different spots, but it's only addressed in one code section in the bill as it's written.
So
I think it should be code section 16590 and 16591. I think that's the intent of the drafter.
So you're talking about line 8
Okay.
right now?
Yeah.
Yield to Senator Parent. Is that okay?
Believe that, and I think like counsel is gonna probably do a better job than me, but the definition is in 90.
Right.
And it applies to both. Am I right?
Are you Mike too?
Thank you. Yes, Senator, that's correct. The definition refers to as used in this article. And so that would refer to all of the code sections in Article 7. So not, which would be both the stalking and the aggravated stalking charge. There are 7 different code sections in Article 7, and that definition would apply to all of those code sections.
All right. No other questions for you, Judge. Thank you for being here.
All right. Thank you very much for your time.
We have one other person signed to speak on the bill, Ms. Kylie Elliott. Georgia Council on Family Violence. Good afternoon.
Good afternoon. Thank you. Good afternoon, Chairman Strickland and members of the committee. Thank you for allowing me a moment. I know you guys have already given a lot of consideration to this bill, and I'm appreciative of that. As you may recall from the last session, I also gave testimony in favor of Senate Bill 197. And I work for the Georgia Commission on Family Violence. I'm also an alumni of the UCA's Georgia Women's Policy Institute, which first worked to bring this bill with Senator Jackson or help her with this bill. I'm here today to convey my support, not just from the commission, but also the Georgia Coalition Against Domestic Violence, the YMCA of Greater Atlanta, and other partners that we have that are talking about this problem of stalking that exists in Georgia and nationwide. Each year, roughly 4% of women and 2% of men experience stalking in the United States. That includes roughly 312,000 men and women in Georgia, which would roughly be enough to fill State Farm Arena 15 times each year. It's a huge portion. And of that 312,000 people in Georgia, more than half of them are experiencing stalking at the hands of their current or former intimate partners. So simply put, stalking is not a stranger problem. It's a problem impacting our families in Georgia, and it's a significant impactor for intimate partner homicide. In fact, in Georgia, our data tells us that 58% of women that are ultimately killed by their former intimate partner have experienced stalking in the year prior to their death. Now, that doesn't mean that a charge of stalking was taken or there were criminal cases. It means they were experiencing the actions of stalking. Because quite often, a lot of people that are experiencing stalking are not able to get those criminal charges because of these challenges. So despite all that, stalking is still widely misunderstood, so much so that over the past year, the commission, along with 16 other multidisciplinary partners, including the Prosecuting Attorneys Council, the Criminal Justice Coordinating Council, Georgia Legal Services, the U.S. Attorney's Office, and the FBI have all partnered in a year-long project to enhance our understanding of the nuances of stalking. And we have trained over 1,300 prosecutors, prosecutors, law enforcement, and community partners on the issue. This training initiative has gone a long way to helping us understand the complex issues involving stalking. But what we really know is context is it's a largely unenforced crime that goes without consequences for the stalker. And we've discussed a great deal today, what makes up stalking, that it requires a pattern, that no single action is going to get it, that it has to be intimidating and harassing, that it can't have the victim's consent, that it has to place the victim in reasonable fear. And then, of course, right now, currently, the law says it has to happen in a home other than the stalker's home. And that last component, obviously, is what we need to address. Because when we look at it, as we said earlier, 47 other states have already said this is not okay. This is not what we're going to do. And they have amended and changed their states. Currently, Georgia only sits with Illinois and Wyoming on allowing this exclusionary language. And unfortunately, what this implication tells victims is that we don't believe that partners that engage in stalking behavior should be held accountable if that stalker lives with the victim. And it's a serious problem given that our data shows us that more than half of all stalkers are current and former victim intimate partners. So SB 197 provides a fix. And I think it goes well. The original stalking law was generated many years ago, and Georgia Court of Appeals in 2018 issued a decision in Bruno versus Light, where they said Georgia's stalking laws were drafted to protect people, not places. And I think that's important to denote. So SB 197 affirms this ruling and plainly states that stalking is stalking regardless of the location. And so finally, I'll give you one last example to kind of ponder today, and it will kind of feed into some of the things you guys have talked about. I worked in the field in TPO offices and with domestic violence victims for many years before joining the commission. And at one time I worked with a woman named Megan, and she and Jason were in a relationship and they shared a home. Okay. And after several years, the relationship broke down, and Megan asked Jason, let her know that she wanted to end the relationship, and she asked him to ultimately make plans to move out. Jason flat out refused. And he also said, this relationship isn't over either. I'm not agreeing to that. He was convinced that she had found someone else, and so he was going to catch her in that, right? So he downloaded a tracking app on her phone, and that way he could monitor where she was when she left the house. And he called and texted her sometimes hundreds of times a day, even when they were at home. And so Megan tried to handle this problem on her own. She moved into the guest bedroom, she put a lock on the door, and she changed her phone number. She did good things, right? She tried to handle this. He wouldn't be deterred. He downloaded spoofing apps that allowed him to call her using alternate phone numbers so she would answer. And then he would sit outside her bedroom door for hours on end every night, yelling at her, telling her about, you're never leaving me. This isn't over. There is no other man for you. She started to get a little nervous. And then she found out that he also had installed cameras inside the home so that he would always know when someone was coming or going. Practically speaking, Megan had no privacy. She had no freedom, and she felt very trapped. She went to the police because she was getting a little bit scared when he started talking about how it was never going to end. And the police said, I'm sorry, I don't think there's nothing we can do, but you should go get a TPO. So she went to the courthouse. And the judge told her, I'm sorry, you guys live together. There's nothing we can do. And as she was leaving the courthouse, she called me back the next day, or called me back just a little while later and said, I just got a text where he demanded to know, why are you at the courthouse? What are you doing? You better get home now. That victim had to go home. Her only solution was to go home, calm him down, and make up some other random excuse for why she was at the courthouse. Because what she knew, and what we taught her with our rules, was that he knew everything, he saw everything, and she literally had nowhere to turn. So while the story is heartbreaking to me, it's not uncommon. We're talking a lot about these situations where, maybe someone is trying to trap the other person and steal their home. That's what's uncommon. What is common is, unfortunately, these people portraying these behaviors in the home, and victims having no way to get out. So instead of giving Megan a sense of safety and a plan for how she could get her life back, like everyone deserves, she was forced to live in a situation of obviously escalating danger. And some of her critics would say that perhaps Megan should have went after the wiretapping law, something like that. But she went to the police. That's where you go to report crimes, and she was denied because they don't see it that way, because the wiretapping law has all sorts of options to protect the person placing surveillance. They have protections that say, it can be used for security and it has to be done in a clandestine manner. The reality is, a lot of the times victims know they're being watched. They just don't have a voice or the ability to speak up because that's how power and control dynamics work. Victims of stalking deserve the ability to avail themselves to both criminal and civil remedies. TPOs offer things that criminal bond orders don't. They offer opportunities for victims to meet with victim advocates and get safety plans and figure out how to exit dangerous situations safely. That's the heart of what SB 197 does. It allows the actions that make up stalking to stand on their own without an escape clause. It gives victims access to critical protection and resources, and it saves lives. Thank you for the time, and I'm happy to answer any questions if you have any for me.
Thank you. Any questions for Ms. Elliott? All right, thank you very much. The last one signed up to speak. I think it's obvious. I think everybody's acknowledged there's a hole in the law that needs to be addressed. It's just a matter of making sure we're doing it the right way. And the good thing about being so early in session is we have time to do that. And so we're going to hold and reset this for another hearing, give you a chance to speak with the committee members and see if we can come up with something that we think is the best shot at doing this the right way. I appreciate you. All right. We're going to move on now to Senate Bill 332. Senator Albers. That's what I was just about to. And we are working off a substitute, and tell me if this is correct, LC 3650001S. Is that right?
That is correct, Mr. Chairman.
All right, Senator, the floor is yours.
Well, thank you, Mr. Chairman. In this august committee, I bring before you Senate Bill 332, which is the Informed Consumers Act. I'd like to begin by giving an introduction and overview, and then take you section by section through this bill. This legislation is really phase 2 of what we began last year, right here in the Senate, of addressing a serious and ever-growing crime in the state of Georgia called organized retail crime. $69 billion is the total amount of loss in 2021 throughout our nation. In fact, one of our hallmark companies right here that employs tens of thousands of Georgians, Home Depot, lost $1 billion last year alone. It doesn't really matter where you live or where you work or where you shop. It's urban, it's rural, and it's suburban, and it's happening everywhere. And it's devastating to our stores, to our jobs, and ultimately to our consumers. You need to know where you're buying your goods from. Doesn't matter whether it's tools, food, or yes, even baby formula. Similar to the work we did to combat metal theft many years ago, as well as assure there was no criminal activity happening in pawn shops, this goes after those organized criminals. Now, just to set the record, this is not going after petty theft and shoplifters. This is the big organized crime. These are anonymous sellers who have taken their business online with technology and innovation. Organized retail crime is very sophisticated. It is used to typically fund gang activity, drugs, and human trafficking. It's orchestrated by professionals who typically use our most vulnerable Georgians to do their legwork and taking advantage of them. And it's time that those professional criminals are held to account and we bring down this organized activity. As we all know, Georgia is the #1 place to do business, and we're very proud of that. And we want to make it clear that Georgia will be the last place that you can come and commit organized retail crime. Now, this legislation targets those thieves by holding the merchants who purchase gift cards for cash on the secondary market to the same standard we hold today for pawn shops. And it addresses the electronic resale on the internet of stolen and fraudulent goods in very high volumes. And I'll give some examples later. We want to make sure that this is not going to be burdensome. This is not going to be difficult, but it's going to be true. It's going to provide for accuracy, and it's going to provide for a level playing field to make sure things are done in a fair and secure method. So overall, what is this? The Informed Consumer Act is going to protect consumers by requiring the online marketplaces, which we'll talk about in a moment, to collect and simply verify these third-party sellers' information. Things like government ID, tax ID, bank account information, and other contact information should there be a problem. And these are high volume sellers. Now, thankfully, there's been a federal bill that has been introduced. The bill you have in front of you today is over 98% identical to that federal bill. Why is it different? Well, there's some things that we don't have, like an FTC, and we have a state attorney general, but it is almost identical. And I'm very proud to report in your folder, you've got a copy of those retailers who endorsed that federal bill. In fact, I will mention some of the quotes and endorsements later. So let me take you through the actual bill itself. While the bill is a little lengthy, you have seen some of this similar language last year. So section 1 is pretty similar to this title, the Informed Consumers Act. Section 2 is the definition, and I want to take you through these because they're important. First is, what is a consumer product? This is tangible personal property, items that you're going to then sell through commerce. The next is high volume third-party reseller. This is someone who is doing 200 or more transactions and $5,000 a year of gross revenue in a 12-month period. So let me give you an example. This is not you took grandma's old dresser and you repainted it and put it up on eBay to sell it. These are folks that are doing this for a living. Now, what you might be thinking is, well, gosh, John, if somebody got up to $4,999 and then shut their marketplace down and created another one, couldn't they do that? Well, the answer is they could. It's not so dissimilar to getting a warning instead of a speeding ticket. Doesn't mean you won't speed again. However, when we catch you the next time, you're going to get a ticket. In this case, it also means we've captured the information of those individuals so we can see a pattern of that happening. The next is, what is an online marketplace? Most of us know that today as Amazon, eBay, Facebook, Etsy, and dozens more. These are just persons or an entity that operates a consumer-directed platform in order to sell goods and services. Who is a seller? A seller is a person who sells or contracts to sell items on an online marketplace. That can be a person, a business, or the marketplace. What's a third-party seller? Well, that's different than a direct seller, obviously, right? And that seller operates on a marketplace or a business that provides information and goods through the marketplace. Verify is going to be an important word in this because we want to make sure somebody is real. We want to verify the information and documents provided on an online marketplace are verified and accurate, and using different methods to determine that it's a real person. As an example, so many times we've all gone, who's not gotten an Amazon package delivered to their house? Probably everybody in this room. But when you're going through and you're searching and you're buying, you're assuming that it's a legitimate person behind that. We can show you example where you clicked on it and it was a vacant lot in Detroit, Michigan. And when your product got there, that wasn't the product you had. In some cases, it's fraudulent baby formula. There's no recourse to even find out who that person was or where it really came from. The next on line 55 is data collection. This, again, very consistent with the federal legislation. And they are the 6 things that are readily available by anyone who is operating a business or selling things personally. Online marketplaces will give people 10 days to provide this information. Bank account information, because online you have to get the money back somehow, some way. Contact information, basic stuff, individual or a business name, a working email address, and a phone number. A government ID or government tax record, again, including name, address, information. A business ID or a taxpayer ID if you are not a business. And again, these are the same type of tools we use for pawn shops and for metal theft, which have been very successful. Then on line 76, we go to annual certification, just like we all have to do in so many things for our businesses. I know many of us operate with LLCs and LLPs or corporations. We have an annual process to make sure that that information is accurate and has not changed. On line 88, suspension. If a high volume third-party seller does not do the things that are required here, they will get 10 days of notice that the online marketplace will suspend them. Now, there's going to be a question or a comment that's likely to come up from one of my friends behind me when they speak about this bill. They're going to say, oh, 10 days, that won't work. If you operate an online marketplace for your business, you're online all day long, every single day. That's what you do. So to have 10 full days of being there is by no means a burden. Next is suspension. Pretty straightforward. If someone does not meet these guidelines, they will be given 10 days and they will suspend it until they provide the accurate information. Then beginning of line 93, verification. Again, they will have 10 days after collecting information. And if a high volume third-party seller provides a valid information, then they will be assumed verified and done. This is not made to be a hindrance. It's made to be a protection. Next is disclosure to customers and consumers. This is very important because at the end of the day, Georgia consumers bear the brunt of this. They're the ones that get fraudulent goods, or after those billions of dollars are stolen, what happens? That cost gets translated down to our Georgia families, the people who are trying to buy groceries, to make their house payment, their car payment, and to put the very things into their lives and their family that we need on a daily basis. They ultimately bear the burden. And this bill is going to require all those high volume third-party resellers with $20,000 or more of gross revenue to disclose very basic and reasonable information. Their full name, whether they're an individual or they're operating as a business, a physical address, and contact information, phone number, email address, other means of connection. A lot of people will do submittal forms, they'll do online chats. All that innovation is good. Now, the federal version of this bill allows for it to only be post-sale disclosure. And working with our partners here, we've actually made it even easier. We said we can do that pre or post-sale to make it even better. It's important to note that we worked with all the stakeholders here, and we did make several modifications in order to ease anyone's concerns. Then beginning on lines 118, under the disclosure to consumers section, this also requires the marketplace to disclose whether the seller is using a different person or seller to do the product. So as an example, I bought on Amazon baby formula because I thought it was coming from this specific seller, but then they subbed that through another third party. Well, that could be a problem because you want to go to the place that you trust and where you're getting it from. And then protection for sellers and partial disclosure, which begins on line 122. If the high volume third-party reseller only has a residential address, let's say they're working out of their home and they don't have a business, this gives them the option to put in the city, the county, and other information so they don't have to put their home online. Same thing with their cell phone number. Data privacy. This begins on line 163. We're all concerned about data privacy these days. And this simply says that they cannot collect your information to use it for other purposes in other marketplaces, and they have to keep it safe and secure. Next is the Attorney General enforcement, and we're almost done. Lines 171. The Attorney General of Georgia can bring a civil action against the online marketplace to enjoin further violations, enforce compliance, obtain damages, restitution, or other compensation, or obtain other remedies as he or she sees fit. This is consistent with the federal bill, which give those exact powers to state attorney generals. This is not new authority. It's actually related directly to the existing Fair Business Practice Act. I want to be sure you understand this does not prohibit any district attorney, law enforcement officer, official, agency, or anyone else or court from proceeding against an online marketplace. The federal bill is more expansive because it includes the FTC. Obviously, as a state, we don't have any governance over the Federal Trade Commission. And last but not least, which is Section 3, is we made this bill effective on January 1st of 2023, not the traditional July 1st of this year, to give more time for folks to put this into place. That was, again, another request by some of the online marketplaces. Now, Mr. Chairman and committee members, you're going to get a few questions and some comments as our friends come up here. Let me proactively answer just a couple of them first. The first is, we agree with the federal bill and we think this should be done on the federal level. Well, if we were to wait for the federal government to get anything done, we'd never get anything done. So we all know that that needs to be done on the state level. The next, as I mentioned earlier, there would probably be a comment of how 10 days might be an unreasonable amount of time. Let me reiterate, if your livelihood is operating an online marketplace, you are online every day, all day, and 10 days is no burden whatsoever. Some might say this stifles innovation. It does no such thing. It puts basic protections and parameters, and most importantly, it protects consumers and small businesses. And let me end before I open for questions with what you have in your folders, which is the support for the Informed Consumers Act at the federal level, which again is more than 98% identical to the law that you have in front of you, a future law. From Amazon, quote, "These modifications will protect innovation, giving Amazon and other online marketplaces flexibility in how we stop bad actors." eBay, "The revised Informed Consumer Act no longer places erroneous and burdensome requirements on individuals and small business sellers. These significant modifications will improve the consumer's buying process while protecting millions of American individuals and small businesses selling online. The new Informed Consumer Acts represent an agreed upon path forward for us to allow a safe and transparent buying process while also protecting individuals and small business sellers." And then Etsy. "This bill develops a thoughtful approach to protecting consumers by strengthening and vetting best practices for online marketplaces and enhancing the ability for consumers to know from whom they are buying. The bill does this while also protecting and preserving the privacy and security of the diverse, broad array of goods and honest sellers. It successfully establishes a framework to weed out criminal activity without harming the economic livelihood of America's small online sellers." Mr. Chairman, committee members, this is good legislation. It does good things to protect our businesses and consumers. It does one of the things that we're most proud of, which keeps Georgia the #1 place to do business and make sure we are safe and secure. With that, I would yield for questions.
You brought a substitute to committee. Can you point out the difference between the original draft and the sub? I believe there's only a few lines that were added.
Yes, Mr. Chairman, I do not have that all outlined, but some of the things that we talked about with the Attorney General's powers, just clarifying some of the language that the Attorney General wanted to make sure fit into the Fair Business Practice Act already. Also, we changed the date until January as July, as mentioned, and a couple other very small T's and C's, but I will ask some of the folks behind me who work with a broad coalition. I think you'll also see in your folders in front of you a very broad coalition of some of Georgia's most successful and proudest companies.
All right. Senator Kirkpatrick, question?
Very simple. Thank you, Mr. Chairman. Chairman Albers, two questions. One is, I'm assuming that with regards to the 10 days that you're talking about 10 calendar days because online business goes on not just during business hours. Is that correct?
Yes, it is 10 days straight.
Okay. And then on the disclosure part, you said pre or post transaction. I don't know where that is in the bill.
Sure. Let me pull it up for you real quick here. You're going to look under the area of 102 to 121 under disclosure to consumers. And I'll find the exact line for you in 1 second. I'm going to turn around and ask if one of my friends would tell me what number it is.
Is it around 118? Just trying to be sure I understand it. I'm 23. Okay, I see
Yeah,
it.
there it is. Okay.
Yeah,
Thank you.
123, 124. Thank you very much.
Other questions, Senator Cowsert?
Thank you, Mr. Chairman. Senator, I know you've been passionate about this. I am not recollecting everything that happened with this bill last year, but it seemed to me that there was maybe a Rules Committee substitute or something changed. Didn't we pass it out of this committee and it got along?
We actually passed it completely out of the Senate, and then over in the House, what was considered Section 3 of that bill was taken out as a last minute to get the bill passed. The good news is, and that included a lot of the stuff that you see here today, Senator. The good news is since then, the federal bill has come out and people have agreed upon that framework. And now we are mirroring that federal bill. So that's what's changed from last legislative session till now.
Well, if we already passed it all, why wouldn't this, why we still got 98%? It should be about 10%, whatever didn't pass last year.
Actually, Section 3 was the meat of the bill. It basically was gutted.
Okay. And all right, thank you.
If Congress does act and passes the federal act, do we still need a state law?
I believe we do, Mr. Chairman. I think if you look at certain areas specifically to what the Attorney General has brought up, that would be, nothing would make me happier than to see Washington accomplish something. But I think the current trajectory does not look good.
Are any other questions for the author? All right, we have a lot of folks that signed to speak. I will go through the list. We'll start with Stephen Lofton with the Georgia Retail Association. Good afternoon.
Good afternoon, Chairman Strickland. Thank you so much for allowing me to speak on the bill for, this is my first time in front of the Judiciary Committee, and I don't want to hold that out as a red flag for the bulls to charge through me.
Welcome. We already have some of you mics lit up with questions.
But I see the smiles on their faces. I know what's coming. But my name is Stephen Lofton. I think I've met all of you or known each of you in the past, but I'm now working with the Georgia Retail Association as of about 2 weeks ago. So the Georgia Retail Association was started in 1961. It includes retailers, both large and small, from all over the state. Those retailers provide over 800,000 jobs at over 100,000 retail locations, and they pay more than $20 billion in wages annually. Georgia's retailers collect and remit more than $6 billion in sales taxes to both local and state governments each and every year. I want to thank Chairman Albers for sponsoring Senate Bill 332 and for addressing this very important issue. And Chairman Strickland, thank you and the committee for taking up this important legislation. As Chairman Albers mentioned, the subject is not new. Retail establishments have been dealing with a rising tide of organized theft of their products, both in their stores, out of their trucks, out of the warehouses for quite some time now. And you did the right thing last year. You responded by passing one of the toughest organized retail crime bills in the country. And we thank you for that. We're very appreciative of that effort. And as you'll hear from other speakers, we've already been working with Attorney General Carr, sheriffs and chiefs of police to use that new tool against these operations. Senate Bill 332 is focused on the other side of the equation, the selling of these stolen goods like handheld power tools, like makeup, over-the-counter drugs, baby food, and more. It's shocking, surprising how much is really available online that's been stolen from these retail goods. And they're being sold to an unsuspecting public by using an online marketplace platform with a brand name that you all recognize or brand names that we all recognize to create the appearance of a legitimate business. Right? It's as if someone has taken their, they used to take these things and sell them out of the back of their car. Well, as a consumer, you knew what you were getting when you bought something out of the back of somebody's trunk. But when you go online, that disappears and it looks incredibly legitimate. It looks like something you can trust, and that is abusing our consumers in the state. And that's one of the things that we're seeking to address with this bill. The ease of selling these illicit goods on online marketplaces has attracted organized criminal networks that are looking for a quick buck at a legitimate business's expense. And this issue has real consequences, as Chairman Albers noted, not just for the retail establishments that are being stolen from, but it impacts everyone, as the dollars that are generated from these online sales, for these retail crime rings, are often then used to finance other crimes, narcotics, money laundering, human trafficking, the list goes on. We're asking the state to modernize the consumer protection laws so that consumers are not unwittingly buying stolen and counterfeit goods through these online marketplaces, and also to give law enforcement a new tool, a needed tool to track and prevent these illicit sales and to protect our consumers. I want to be clear, as Chairman Albers noted, this is not going to interfere with folks that are selling something like used golf clubs on Facebook, Marketplace or Etsy or eBay or anything like that. We're talking about high volume sellers selling unused items. And one of the important consumer protection points that is in this bill is requiring these high volume sellers, those that are over $20,000 in a 12-month period, to have a way for consumers to communicate with them directly. That's currently not required on a number of marketplaces, and we feel like it should be, because then it gives that consumer the ability to ask a question. Hey, what am I buying? What's the expiration date on this? Is this something that I can trust? Who are you? It allows that consumer the power for the first time to have those types of conversations, which you would normally have in a retail setting, in a store, a brick and mortar store. I won't go, but Chairman Albers did a fantastic job of explaining the bill and what it does. So, and I know that we're running short on time, Chairman. So I'll just say this is common sense consumer protection legislation. It promotes safety, transparency, and accountability. And we can go a long way towards solving this problem by passing this legislation. It's already been enacted in one state. Similar legislation has been filed in over 20 others. And the support that this legislation is getting at the state level is helping to move the federal legislation forward. So it's important that we continue that progress, that momentum here in Georgia as well. With that, Chairman, I'll wrap up just by saying the members of the Georgia Retail Association ask for your favorable consideration of Senate Bill 332. I'm happy to answer whatever questions I'm capable of answering.
Any questions, Mr. Lofton? All right, thank you very much.
Thank you, Chairman.
Come back again to Senate Judiciary. It's always this exciting. Don't laugh at that, John. You got a bill in front of us. We have Hilary Thrower and Kelly Harrington with Home Depot. If y'all both want to come up, you can. I'll turn both of y'all's mics on.
This is also my first time in front of the esteemed Judiciary Committee.
You're
so
welcome. Esteemed. I keep hearing that word.
I'm used to testifying in front of healthcare, so this is a little different. Thank you, Mr. Chairman, members of the committee. My name is Hilary Thrower, and I serve as Senior Manager of State and Local Government Relations for the Home Depot. And we're here to testify in support of Senate Bill 332. As you know, the Home Depot, which is the world's largest home improvement retailer, is a homegrown company. Founded right up the road in Marietta in 1978. And since then, we have been and continue to be a proud Georgia company. The Home Depot currently has more than 31,000 Georgia associates, 90 stores, 15 distribution centers, and an annual economic impact to Georgia of $10.4 billion. So just like the Georgia Bulldogs and the Atlanta Braves, the Home Depot is your home team. So one of the reasons Home Depot sees the need for this legislation is the rapid growth of organized retail crime and its impact on our stores. Now, to be clear, organized retail crime is not petty shoplifting. It's theft for greed, not theft for need. These are sophisticated criminals that recruit individuals and steal from retailers, both big and small, and then resell in online marketplaces hiding behind fake screen names. And as Senator Albers discussed, the retail industry and the online marketplaces have been hard at work over the last year, coming to an agreement that resulted in a bill that has been introduced in Congress, a bill that has the written endorsement of several large online marketplaces, as he mentioned. So that same agreed upon policy is before you today as Senate Bill 332. And as you've heard plenty of times before, we'd love to see a federal bill pass, but we know that that can take some time. And so in the meantime, we can't just stand idly by waiting on the feds to take care of Georgia consumers and your constituents. So with me today is Kelly Harrington. Kelly serves on the asset protection team at the Home Depot, and he sees these cases every day. He knows what it looks like for this lack of online marketplace transparency and what its impact is to our stores. So if it's okay with you, I'd like to have him speak and then we can answer any questions.
Thank you, Hilary. Great job. This is also my first time here, but good afternoon, Chairman Strickland and members of the committee. My name is Kelly Harrington, and I currently work for the Home Depot in the role of Senior Manager Asset Protection. I oversee our investigations team for the Southern Division of the company. First and foremost, we want to thank you for your support of House Bill 327. That was a great step in the way of being able to hold these criminal actors accountable, these actors that are impacting our business financially and significantly. This is a great first step, but we're not done yet. The Home Depot is relying not only on you to help with this problem. We've worked very hard internally, innovating with technology solutions. Some examples of that include the locking carts that we put into our stores in some test markets, as well as the limited egress gates. Those of you that shop our aisles probably see the lockup cages that keep the high value portable power merchandise that's commonly targeted with these types of schemes on the shelf and in stock for the consumer. While we continue this innovation, it's not enough to control the rapidly increasing rate of organized retail theft. The opportunity presented by Senator Albers, among the others, is the emergence and ease of access to online marketplaces. They resell stolen property, and we call that fencing. That is the crime being committed. While these marketplaces are a great outlet for the secondhand consumer market, they need accountability measures to drive honest and legitimate sellers' business while keeping our organized retail crime actors out. Today, pawn shops have stringent requirements, as mentioned earlier. To sell to a pawn shop, you have to say who you are. They have a database. It tracks what you sell to the pawn shop. That data is readily accessible to law enforcement partners for the purposes of furthering investigations. On the e-commerce side, we don't have that benefit, and anyone can sell stolen goods without accountability. And I may note, pawn shops often operate e-commerce in parallel to their brick and mortar business for the purpose of fencing and hiding the good stuff that they're selling that's stolen from our stores. We need process standardization that enables us to know what data is captured by these marketplaces and how we gain access to that data, whether it be through law enforcement under a subpoena or as a retail partner conducting an investigation. Whether you are a concerned consumer or a retail theft investigator, disclosure of who a seller is throughout the process should be available to purchase or shop online. This bill doesn't hurt or slow down honest sellers. It would simply drive accountability and common sense business documentation for all sellers while offering the benefit of deterring criminal behavior and capturing data that can be used to supplement investigations when crimes are committed. We at the Home Depot thank you all for your support and would like to ask for your support on 332 Senate bill. Thank you.
And thank you, Mr. Harrington and Ms. Thrower. We have a question, Senator Rhett.
Thank you, Mr. Chairman. I like the bill and I like the concept, but I just have a small technical question. You mentioned that pawn shops have a database. Would retailers be required to do that? And if so, would there be a cost involved?
In this bill, retailers would not be required to. This is just for the online marketplaces.
Okay, thank you. I just want to clear that up.
Pretty much. Any other questions from the committee? All right, thank you all very much. Next, we have Jay Morgan with eBay. Good afternoon.
Good afternoon. My name is Jay Morgan. As Chairman mentioned, I represent eBay here in Georgia. This is not my first time before the committee, and perhaps I wish it was, given the reception that others have had. I want to thank you, all of you, for your service. It is not lost on all of us in the hall, the sacrifice that you and your families make for you to be here. And so thank you for that. For over 26 years now, eBay has existed to provide an open and vibrant marketplace for buyers and sellers worldwide and to foster economic opportunity, especially here in the #1 state for business. We greatly appreciate Senator Albers' leadership in authoring Senate Bill 332 to generally align it with the bipartisan, bicameral Federal Informed Consumers Act moving through Congress. Likewise, salute the chairman's efforts to make sure this bill is fair for all those that are affected. Most importantly, those small businesses that will need to comply. And just as an aside, I'd like to congratulate Stephen Lofton on his new assignment here with the Retail Association. So as you know, eBay is not a retailer. We do not buy or sell goods, nor do we compete with our sellers by manufacturing or selling products on our own. We succeed when entrepreneurs and small businesses that use our platform succeed. And during the pandemic, eBay literally saved many small businesses across our state. We connect over 220,000 Georgia sellers, including private individuals and business sellers. I want to say that again, 220,000 Georgia sellers. And I would dare say that there are some of those in every one of the districts represented by each of you here today. We succeed when our sellers succeed, and we strive to keep eBay the safest and most secure marketplace to earn the trust of all consumers. Senator Albers quoted our statement about the federal bill, and let me be clear, we do support the informed legislation which has been carefully negotiated with all the major players represented here today. We support one federal standard, and the 98% that he talks about would be 100% if this bill reflected that. Similar state legislation has now been introduced in 20+ states. And while hybrid versions with different requirements are under consideration, most lawmakers have acknowledged the importance of aligning the federal bill. Only 2 states have promoted the differing disclosure language, which we have indicated to the author and the proponents that is our concern. We believe it's fair to ask this simple question. Do you support the consensus federal bill? And if so, why are you supporting different language here in Georgia? Our primary concern today is that the cumulative effect of these differences, if enacted, would lead to a regulatory patchwork that does not advance the goals of curtailing stolen or counterfeit goods. We believe that the approach in the federal bill provides transparency to consumers in a balanced way that protects millions of American individuals. Of note, that legislation establishes a national standard that does in fact preempt differing state requirements. The Informed Consumers Act is poised to be enacted by legislative leaders this year, after only first being considered last year. Further, we would strongly encourage the formation of an online retail crime task force that brings together the right people from different law enforcement agencies across our state, retailers, online marketplaces, and other key partners to collaborate on complex investigations that will hold those engaged in organized retail crime accountable. We have a strong track record of working with law enforcement and our retail partners, and we firmly believe that a collaborative approach will best benefit Georgia consumers and businesses rather than a state patchwork of seller verification laws. eBay's commitment to consumer safety and rights owners protection is longstanding. It's a central value to our company. Simply put, bad actors are not welcome on eBay. We proactively partner with retailers, brands, and regulators, and work collaboratively with law enforcement and other relevant stakeholders to enforce our policies and to find and remove bad actors unlawfully using our marketplace. Our PROACT program is an industry leader in partnering with retailers and law enforcement to identify stolen goods. Described by many retailers, loss prevention professionals, and law enforcement officials as the gold standard, we are proud to work collaboratively to keep our platform safe for all our users. So thank you for the opportunity to share our overarching concerns with Senate Bill 332. As an e-commerce leader in developing policies and tools to combat infringing or unsafe goods on our platform, we welcome the opportunity to work together to combat bad actors while we support small businesses here in Georgia. We must respectfully oppose Senate Bill 332 as we believe it should reflect the discussions and agreements reached at the national level. Online retail crime does not respect state boundaries, and a patchwork of state laws will not have the intended effect of this legislation, nor is it fair for small businesses to have to shoulder the burden of that same patchwork quilt of regulation and compliance. Thank you, Mr. Chairman.
Thank you, Mr. Morgan. The federal law, if it's passed, will it preempt state law such as this
That's
one?
my understanding, sir. I'm not an attorney, but I would.
I know
leave that
there's
to
any
your-
language in that federal bill that even may state that. I don't know the answer. I don't know if you know.
I'm sorry?
Is there any language in that federal bill that discusses preempting the local laws directly? Do you know?
I'm not certain.
And they'll
I'd
be
be
the
happy
state
to find
laws.
out the answer for you.
It seems as if that's the case, then what harm is there in passing a law in Georgia until the federal government does act?
That's certainly an issue for you guys to decide.
Okay. Any other questions for Mr. Morgan? All right, thank you. Next, we have John Watson with Amazon.
Thank you, Mr. Chairman.
Not your first time either.
No, indeed. I hope everybody's well. I'm going to be very quick to the point. It's been a while. You guys have been here a while. I do have 3 asks associated with this bill. Jay discussed many of the items at a strategic level, the federal level, and we do believe that at Amazon, from an Amazon perspective, that this is a federal issue. That nonetheless, and on the sign-up sheet, Mr. Chairman, there was support, oppose, and I wish there was an answer for trying to get there. And so here's where I'm trying to get.
Hey, John, hold 1 second. I was told your mic is not being picked up. Go to mic 1 just to be safe. I'm sorry. I'm gonna throw you off.
No, I was on a roll, Mr. Chairman.
I know, but nobody was hearing you except us.
So the necessity of my ask on unhindered is in particular in communication that is buyer-seller messaging tools. We are monitoring that process to impair and stay ahead of the fraudsters that we are working diligently against. In as late as 2019, $500 million spent by Amazon. So if the word unhindered could be construed that we, in our duties as monitoring, are actually aiding and abetting the bad guys because we could be impaired or hindered from doing our job. That's the most important thing that I am trying to stress to the community, to the committee. Conversely, if you look at line 117, by reading other means of direct electronic messaging, which may be provided to such high volume third-party seller by the online marketplace, we are seeking an addition at this point, provided new language. The requirements of this subsection shall not prevent an online marketplace from preventing fraud, abuse, or spam through such communication. Again, it's trying to put belt and suspenders on this statute that makes it abundantly clear that we have the flexibility as the responsible marketplace overseer, so to speak, to continuously be doing everything that we can. As the sponsor, Senator Albers, said, these are extremely sophisticated bad actors. And the more that we have an environment of flexibility and innovation to fight them is what we are benefited by. Last point, ladies and gentlemen, then I'll move on. Indeed, we are asking for an additional 10 days for small businesses, many of which these third-party sellers are, to make certain that they do not miss a notice that they've been provided, and make certain that we have and they have 10 more days to comply and make certain they are giving us the information for an annual certification process and that we are not forced to throw them offline. Again, strategy-wise, we are aligned. We are asking not for ourselves, but for third-party sellers, many of which are Georgia small businesses, a little bit more runway to notice our notice to them and give us the information necessary to keep them online. And that's it.
All right, thank you. Any questions for Mr. Watson? All right, thank you.
Mr. Chairman.
Next, we have Carlos Gonzalez with Walgreens. Good afternoon.
Good afternoon. Thank you for having me.
Thank you.
Good afternoon, Chair, committee members. Thank you for the opportunity to give me to testify today on behalf of Walgreens to support the Inform Act Senate Bill 332 in the state of Georgia. My name is Carlos Gonzalez, and I'm a major crimes asset protection manager for Walgreens. Today, I have an associate, a colleague of mine that also resides and works here in the state in the asset protection manager role as well. I have been in asset protection for over 23 years and have extensive experience in investigating organized retail crime. My job in major crimes is to prioritize the safety and security of our team members, customers, and communities. I conduct high-level investigations into serial robberies, burglaries, fraud, brand integrity, and organized retail crime. I also help build and foster relationships with public-private partnerships to address and mitigate major crime trends. Within retail, we are a fierce competitor between businesses for sales and for consumers. But we become a force multiplier when we work cohesively as one team when we identify and investigate organized retail crime. We have seen organized retail crime activity increase over time, but lately subjects are becoming more brazen and more violent against team members and innocent bystanders who stand in their way. I can list a myriad of cases that I have helped investigate further to bring fences and boosters to justice over my career. But the common theme amongst all of them is once the efficacy of the products sold by fences and purchased by consumers may be compromised because of the conditions that these merchandise and these items are kept in. And two, fences are becoming more savvy and using online platforms to sell stolen products all over the country and remain anonymous. Over the past several weeks, I have worked with law enforcement to help further an investigation of a booster that has sped away in an Atlanta highway, and they had stolen approximately $2,500 worth of merchandise of over-the-counter and health and beauty items. They in fact jeopardized many motorists that day, and on their way through the town, they actually threw the merchandise out the window, but luckily, safely, they were apprehended and arrested. The police officers were able to recover the merchandise and were able to file charges against those boosters. For the reasons mentioned above, we're asking for the support of the passing of the Inform Act SB 332, which will resolve issues associated with high volume online sellers who are profiting from the sale of stolen merchandise. Thank you for your time today. I'll be more than happy to answer any questions.
Thank you. Any questions, for Mr. Gonzalez? All right, thank you.
Thank you.
Next, we have Glenn Wilkins with Walmart. Good afternoon.
Good afternoon. Thank you for having me, and I'll be brief as well. Oh, if I don't knock this off, so my apologies on that. Let's start out like that. So good afternoon. I am Glenn Wilkins. I'm the Director of Public Affairs and Government Relations for Walmart. Thanks for having me. I do want to say that at Walmart, we have over 70,000 associates in the state of Georgia alone. We have over 214 facilities between supercenters, neighborhood markets, distribution centers, whatnot. It's a wide variety out there. We do support this bill 100% as it is. One thing that was changed, and is something that we were interested in changing, back to my colleague's point, was that we wanted disclosure of the seller pre and post sale. Right now, it said that it was going to be post sale only. We thought it would be a great opportunity to let the individual marketplace decide when the disclosure of the seller is, whether it's at the beginning of the sale. So if I know I'm going to be buying it from someone from Ohio, or if it's someone from China or wherever it is, at least I'm aware of that prior to the sale. So that's something that we felt gave flexibility to the marketplace. To that point, Walmart is unique in the sense that we do have bricks and mortar in the state and in the country. We also sell our own name brand product online, but we also hold a marketplace. So what we do in our stores, we have over 100,000 SKU items that are inside a super center. We also provide space online through a marketplace for over 100,000 individual sellers as well. Those sellers are large and small. So we feel that we provide a great opportunity for people to actually get inside of our stores without having to get inside the store. So those small sellers, those vendors, those business owners, if they can't provide to be on a shelf space in a super center, they can go online and provide that opportunity from people across the country and around the world. Those are some of the main things I want to hit on. I'm trying to remember, there's, let me see, that was the change. Oh, as far as the seller's information being disclosed within 10 days, we think 10 days is more than adequate. If their account gets suspended, all they have to do is give the important information. They just give the information that any other business has to submit when they're turning in their business license if they were a brick and mortar. As soon as they provide that information, it's lifted and they continue to sell. So I'm going to leave it at that. If there are any other questions out there, I'm happy to answer.
Thank you. Any questions for Mr. Wilkins? Senator Cowser.
I got one. You know, we've seen some of the numbers of the amount of loss. They're just huge amounts of merchandise missing. I mean, this isn't people breaking and entering your stores. It's inside deals, or how are they getting away with 300, power tools?
Yeah. So what we see a lot of, we see everything, right? We see the hard lines. We see the TVs going out the back door, don't even make it in. We also see a lot of over-the-counter kind of products that are being stolen. I think Walgreens and Publix and other folks would attest to this. This is where they're coming in, they're given a list of what they need stolen so they can go and sell it online, which, because of the thresholds that are in place, is it cumulative, which was addressed last year. You guys did a great job on that. They know how much they can get away with, and then they're going to go and sell it online. I know we have some other folks out here who will say this as well, but one of the challenges that we face, it isn't for us the power tools so much as it is it's consumables, over the counter, it's ibuprofen, it's cosmetics. When it's stolen, it's stored in many areas that are not climate controlled. The chemical compound changes that. It's been purchased over online, and then they consume it, and you don't know what kind of reaction the individual is going to have to. So we think it's important to make sure that we're identifying who is selling it, and we can see who those individuals are. I think Amazon, I think eBay, I think Etsy does a great job right now already. Let's make sure we get the right information. We want to make sure you are a good seller. We bust our butts to get that done as well. But we want to make sure that it's required of all marketplaces out there, that we're all playing by the same rules.
So just one follow-up, Mr. Chairman. So what are you guys doing for loss prevention? I mean, it sounds like, you're failing miserably. Either people are shoplifting, or you don't have, good locks on your doors, security, and now you're asking these on-place marketplaces to help you do your job of loss prevention.
Sure. So we're not asking them to do that. We actually work very closely with Home Depot, with Lowe's, with everyone here. We talk about best practices to figure out how to best save the product in our store and save costs for our customer. A lot of it does come down to the safety of our associates. Someone's walking out with a TV.
Yeah.
Their life, their health is not worth them stepping in front of someone for that, right? So this is just an avenue. If we can reduce that opportunity of having bad actors selling online and take that tool away from them, we think that we're actually winning on that.
Thank you.
Thank you.
Senator Kennedy.
Thank you, Mr. Chairman. So the numbers we've heard from you and some of the other speakers and Chairman Albers as well about the losses, as Senator Cowser said, are huge. They're astounding. And it strikes me that that's not the kind of loss that is typically one that you can insure against. But it just prompted the question, are these losses actually being squarely shouldered by the retailers where the product would have ordinarily been sold from? Or A, is there any form of insurance that's providing any sort of loss prevention or mitigation, not prevention, but mitigation for the ultimate financial damage? And number two, do you have incidents where you've got a shipper that somehow didn't do something they were supposed to do, and some of the loss falls back on them if we're talking about product that didn't actually make it into the store? I'm just wondering, and the simple answer may be it's all on the retailers, or there might be a variation. I just wonder which is it.
So I can't speak to it in detail. I do know that when it comes to whatever our loss is for that year, that's put into the budget. So when they put their budget together for the year, they say, we're going to do X amount of sale, and we know we're going to have X amount of loss. We know that percentage has increased over time or decreased, and that just becomes part of their operating budget. So it falls on that store and it falls on that business specifically. So, yeah.
Any other questions for Mr. Wilkins? All right, thank you.
Thank you.
Next, we have Amanda Seals with the Cobb Chamber of Commerce.
In the respective time, Mr. Chairman, you have a letter of support in your folder.
Okay, thank you. And just so everybody's clear online too, she said there's a letter of support that was already given in our folders for her testimony we'll have. Next, we have Brian Hudson representing CVS. Did you have a letter, Brian? Or no letter? Okay.
Thanks, Mr. Chairman. I actually have the honor of representing Home Depot as well as CVS, but since Hilary and Kelly already spoke, I'm just going to be real brief. So on behalf of CVS, we have 7,100 employees in Georgia, about 350 locations, and just a couple of stats that kind of jump on Chairman Cowser's point about just the numbers and Senator Kennedy's point as well. In CVS, every 3 minutes, an ORC event occurs in a CVS store, every 3 minutes. Organized criminals steal an average of $2,000 in just 2 minutes. And just think about that. And to your question, Chairman Cowser, I know that a lot of these retailers are doing their own efforts, whether it's locking carts, as Kelly from Home Depot mentioned, or locking up drills and things like that. So I think I can speak for all the retailers that at least the ones that are part of our coalition, we are doing our best to try to combat these criminals. And unfortunately, they get more creative as time goes on. And as they get creative, we try to adjust as well. So with that being said, Mr. Chairman, I just want to lend CVS's support for the legislation as well. Thank you.
All right, thank you. We have a question, Senator Cowser.
I'm curious, and by the way, I'm not blaming the retailers. When I see this stuff that's been going on recently, the almost flash mobs just bull rushing, I mean, there's no defense to that. And if they're doing that to grab items to go give back to the dude that resells them online, then I mean, we're just going to have to start closing stores if we can't, put up burglar bars or something.
Mr. Chairman, you're exactly right. And that's happening, unfortunately. There are retailers that are closing stores because of this activity in certain jurisdictions around the country. Obviously, we don't want that to happen in Georgia. And yeah, you're right. I mean, once you get to a point where you have a flash mob and there's not a whole lot you can do about it. And I think Glenn with Walmart mentioned, it's not worth any of the retailers' associates or our customers' lives to go after these people that are leaving with carts full. So hopefully the locking device where you have a cart full of electronics or tools or baby formula, and you get to the checkout area and it locks up on you. Hopefully they'll drop the cart and leave. I think that's the idea with the Home Depot technology. I know it's worked in some stores around the country as it relates to just shopping cart theft.
Have any other states passed a similar law?
So Arkansas passed a bill last year that was actually based on the federal bill from last year. So just not to confuse everybody, Mr. Chair, I'm sorry to be so long-winded here, but I'm sure you're not surprised by that. But so when I say last year, I guess I'm referring to 20. There was federal legislation that really only passed in one state. It was Arkansas. And so I think a lot of folks before me mentioned this. At that point, the online marketplaces as well as the retailers got together and came to negotiations at the federal level to introduce new bills. And I think Mr. Morgan mentioned this. There's a Senate bill that's bipartisan. There's a House bill that's bipartisan. And this legislation that Chairman Alberts has brought forward is nearly identical. There's a few things that are different, but overall it is nearly identical to the federal bill. And so, and a lot of this is negotiated at the federal level. And I just want to say this as well to Amazon's point about the 10 days. That was actually a negotiated issue. That the 10 days that are currently in the bill was actually negotiated between the online marketplaces and the retailers at the federal level. And so that's why we mirrored it here with Senator Albert's bill. So, thanks.
Any other questions for Mr. Hudson?
Thank you.
All right, thank you. We do have a question. Not for him.
I just wanted to see if Kathy had anything she wanted.
She's my last speaker. I was about to recognize her. Got somebody looking out for you on the committee.
Thank you so much, Mr. Chairman, members of the committee. My name is Kathy Kazav, and I'm the president of the Georgia Georgia Food Industry Association, representing all the supermarkets across the state of Georgia. A couple of things I just wanted to talk about really quickly. When you go to the baby food aisle, this is what I challenge all of you to do. Go to the baby food aisle in your grocery store, and you will see that you can only get one can at a time, and you can't just scoop it all up. It's those kind of things that we're trying to do to make it harder for you to not be able to scoop everything out. Some of the things that you said, Senator Coweta, you mentioned the security right now. There, especially since the pandemic, our stores are under assault. We have got so much theft going on, and as it's been said, it's just not worth anybody's life to stop somebody. So we try to put everything we can in place to try to make this as safe as we can and to alleviate the criminals coming in. But again, it continues to go on. I was part of the Senate access for food deserts that we went across the state, and there is so much crime. There are a lot of stores closing in areas that are just experiencing such high crime. So that does close some of the grocery stores down. I did want to just very, very quickly talk about the baby formula. That is something that has stolen so much from our stores. And that is something that used to be at the flea markets. You'd go down the road and you'd see these things at flea markets or out of somebody's car. All of that has got to be held at the right temperature or it breaks down. And when that is online, people just do not understand how it's being stolen and how it's being accessed right now. So again, this is just a transparency bill. I very much appreciate your time, your patience, and we are very much in favor of Senate Bill 332. Thank you so much.
Thank you. Any questions for? All right. That's everybody that's signed up to speak. Senator Albers, you want quickly the last word, and I will ask you if you I don't know if you addressed the 10 days, but the other two areas that were mentioned, Mr. Watson, do you have any thoughts on what he suggested there?
Certainly. And to my good friend, John Watson back there, unhinged as defined in the Merriam-Webster dictionary is simply not restrained or held back, which means you're not going to obstruct. So it's really necessarily, I appreciate his comment, but it's really not an issue. As Brian Hudson mentioned, again, 10 days is what they've agreed and supported upon. That's what you do every day. And they did inquire about that language. Good to note that we did give in and work together as a team in order to make many changes. We just think that's an unnecessary and inappropriate ad that would take it outside of the deviation of the federal law. This is a bipartisan bill. In fact, many of you here are co-sponsors of this bill. Again, 98% plus the same as the federal law. Look, I really hope the federal government does it. But those are the same folks that can't run a cash for clunkers program. So I'm not optimistic they're going to get this over the goal line anytime in the near future. But here's the great news. If they do, my friends already have 98% of their work done. So we've just helped them get a head start while we protected Georgia consumers, while we protected those who are brick and mortared here and selling goods here. So in summary, thank you for the opportunity to present this bill. This will make a meaningful difference in Georgia, where we care about our consumers and our businesses, and I would ask for your favorable consideration.
Are any last questions for the author? What's the pleasure of the committee? We have a motion to pass by Senator Parent. We have a second by Senator Kirkpatrick. Ladies first. Any discussion? Do we have any amendments? All right, all those in favor of the motion to pass for LC 365001S, please raise your hand. It passed unanimously.
Thank you, Mr. Chairman. Thank you, committee members.
All right, thank you. And with that, we are adjourned. Thank you.